Imagine this, a child torn between two homes, two loving parents, and two entirely different worlds. This is the reality for many families dealing with divorce and custody battles. But at the heart of it all, the question remains, what's best for the child? Let's explore that question today. Hello everyone, I'm your host Shambhavi and you're watching LiveLaw. One of the most heart-wrenching aspects of divorce is deciding what happens to the children. Child custody battles can be emotionally charged, but at the heart of it all is one simple question. What's best for the child? In this episode of Family Law Diaries, we are diving into the legal, emotional, and psychological aspects of child custody in India. We'll discuss the laws that govern custody, important cases, and what parents should keep in mind. Let's start by understanding what child custody means from a legal standpoint. The legal provisions for child custody in India are governed by different laws based on the religion of the parents. For Hindus, the Hindu Minority and Guardianship Act 1956 and the Guardian and Wards Act 1890 are the key statutes. Under the HMGA, Section 6 specifies that the mother is considered the natural guardian of a minor child until the child turns 5. For Muslims, there is no specific statutory provision, and the rules are derived from Muslim personal law, where custody, known as hizanat, typically rests with the mother until a certain age, unless the court decides otherwise in the child's best interest. Other communities like Christians and Parsis are governed by the Indian Divorce Act 1869 and the Parsi Marriage and Divorce Act 1936, respectively. However, the Guardian and Wards Act 1890 acts as a uniform law across all communities when it comes to appointing a guardian for a minor. In India, the application for child custody is primarily filed under the Guardians and Wards Act 1890, specifically under Section 7, which grants the court the authority to appoint a guardian for the welfare of the child. This act applies to all individuals regardless of their religion and is often used in cases where personal laws do not cover custody matters sufficiently. Custody applications can be filed under this section for marriages registered under the Special Marriage Act, allowing the court to pass orders related to custody during matrimonial disputes. The common thread in all these laws is that the court's primary consideration is the welfare of the child. It's not about who the better parent is or who earns more money. It's about which environment is most nurturing for the child. Before moving ahead, let's cover some basic information. Where to file an application for child custody? So the petition for child custody is filed in the appropriate family court or district court having jurisdiction over the matter. Jurisdiction is typically determined based on factors such as the child's habitual residence or the place where the parties last resided together. Now, at what stage? So you can ask for custody of your child at any time during the divorce or separation proceedings. You will need to ask for it as a part of your divorce or separation petition, either in the petition itself or by filing a separate application. So what are the different types of custody in India? Let's break them down. First comes the physical custody. This is the most common type where the child lives with one parent and the other parent gets visitation rights. The custodial parent takes care of the child's daily needs. Coming to joint custody, although not as common in India yet, joint custody is gaining recognition. In the arrangement, both parents share physical custody of the child and the child spends significant time with both the parents. In the case of Yashrita Sahu versus State of Rajasthan, the Supreme Court acknowledged the benefits of joint custody and emphasized that both parents should play an active role in the child's life unless there are exceptional circumstances. Next is legal custody. Even if a parent doesn't have physical custody, they have the right to make important decisions regarding the child's education, healthcare, and overall upbringing. Now, sole custody. In situations where one parent is deemed unfit due to issues like abuse, neglect, or substance abuse, the court may grant sole custody to the other parent. Third-party custody. In rare cases where neither parent is suitable, the court may grant custody to a third party, such as a relative or a guardian. So while these are the typical forms of custody, the court's decision is based on one overarching principle, as already mentioned, the welfare of the child. A concept that comes directly from Section 17 of the Guardian and Wards Act 1890. Although joint custody sounds ideal, it's not commonly awarded in India yet, though there is a growing trend towards shared parenting. Now, there is no hard and fast rule regarding the question of whom to give the custody of the child, but there are few accepted general rules which are highlighted in various decisions of the court in India as well as in England. A minor child or a child of tender age should be generally under the custody of a mother, since the father is not seen as capable of providing maternal affection as needed by a child for his or her proper growth. The boys who are older are generally placed under the custody of the father. The girls who are older are generally placed under the custody of the mother. Ordinarily, custody should be given to either the parents. However, if the welfare of the child so requires, it may be given to a third person. Let's now talk about what factors the court considers when deciding custody. So it's important to understand that the court does not automatically award custody based on the parent's gender or financial status. Instead, it looks at a range of factors. Like court battles over custody can get ugly, but Indian courts take a thoughtful approach when making these decisions. In cases involving older children, courts may even ask the child their preference. However, their opinion is only one of the many factors that the court considers. First is emotional bond with the parent. Which parent has a closer emotional bond with the child? Courts often consider which parent has been more involved in the child's upbringing. Mental and physical well-being of the parent. The mental health and lifestyle of each parent are critical. For example, in Roxanne Sharma versus Arun Sharma 2015, the Supreme Court emphasized that custody should ideally go to the mother when the child is under 5 years of age, unless there are exceptional circumstances or the father can prove that he can better serve the child's welfare. Then comes financial stability. While financial stability is important, it's not the primary factor. Even a financially weaker parent can be granted custody if they can provide a stable and loving environment. The child's education and upbringing. Courts look at the impact on the child's education. Will moving to one parent disrupt the child's schooling or social environment? An important landmark case in this regard is Gaurav Nagpal versus Sumedha Nagpal, where the Supreme Court ruled that the welfare of the child must always take precedence over the parents' personal preferences or their financial or social status. Historically, there has been a strong preference for granting custody to mothers, especially in the case of younger children. But is that still the reality today? Traditionally, mothers have been given preference, particularly for children under 5, as outlined in Section 6 of the Hindu Minority and Guardianship Act 1956. However, courts are becoming more progressive, recognizing the role of both parents in raising a child. In the case of Vivek Singh versus Romani Singh, the court acknowledged the importance of the father's role and stressed that the child's welfare could sometimes be better served by the father. Firstly, the report of the principal counselor in this case stated that the child did not want to change her present environment and that she was more interested in staying with the father. Secondly, for the best interest of the child, though the parents aim to ensure that the child is least affected by the outcome, the inevitability of the uncertainty that follows regarding the child's growth lingers on till the new routine sinks in. The effect of separation of spouses on children psychologically, emotionally, and even to some extent physically spans from negligible to serious, which could be insignificant to noticeably critical. Courts today are more open to awarding custody to fathers if they can prove that they offer a better environment for the child's growth. The Delhi High Court, in the case of Gaurav Nagpal versus Sumedha Nagpal, ruled that the father's role in a child's life is just as important, challenging the traditional bias towards mothers. Still, for very young children, the scales often tip in favor of the mother unless there is clear evidence that she is unfit. The emotional impact of custody battles on children is profound. Psychologists agree that children often feel torn between their parents during custody disputes, which can lead to long-term emotional and behavioral issues. That's why courts now increasingly recommend family counseling to ease the transition and minimize emotional damage. In cases like Neel Ratan Kundu versus Abhijit Kundu, the Supreme Court highlighted the importance of considering the psychological impact on the child. The court ruled that the child's mental health and emotional well-being should be given due weight when deciding custody. Courts often recommend counseling for both the parents and the child. So a stable, nurturing environment is key to a child's healthy development, and courts take this very seriously when making custody decisions. So one term that has gained attention in recent years is parental alienation, where one parent manipulates the child into turning against the other parent during or after a divorce. This is a serious issue that can affect the child's relationship with both parents. PAS is destructive irrespective of the gender of the alienating parent. Every year, thousands of children and parents are experiencing this phenomena of PAS and the resulting devastation it causes. The financial and emotional cost of parental alienation is excessive to the target parent. Courts are now taking note of this, as in cases like Vivek Singh versus Rumani Singh, where the Supreme Court acknowledged the harmful effects of parental alienation and ruled that such behavior can affect custody decisions. So even if one parent is awarded physical custody, the non-custodial parent still has the right to maintain a relationship with the child through visitation rights. So visitation schedules can vary based on court's decision or mutual agreement between the parents. The aim is to ensure that the child maintains a healthy relationship with both parents despite the divorce. Let's quickly cover the types of visitation. Fixed visitation includes set days like weekends or holidays. Reasonable visitation is flexible, allowing parents to decide based on convenience. But visitation isn't just about ticking off legal boxes. It's about ensuring the emotional well-being of the child, allowing them to feel connected to both parents. When it comes to non-resident Indians, NRIs, child custody becomes even more complex due to conflicting laws across borders. The Hague Convention on Child Abduction plays a major role in such cases, ensuring that children are returned to their country of habitual residence. India is not a signatory to the Hague Convention yet, but courts often refer to its principles. A landmark case in this regard is Surya Vadanan versus State of Tamil Nadu, where the Supreme Court emphasized that the welfare of the child takes precedence over jurisdictional issues. Or like in Surinder Kaur Sandhu versus Harbakh Singh Sandhu, the Supreme Court held that the child's welfare comes first, even in international disputes. In this case, the court ruled in favor of the mother despite the father taking the child to the UK without her consent. Courts generally discourage parents from taking children across borders without the other parent's consent, as it complicates the custody battles and often leads to international legal disputes. So under cross-border complications, there can be three different scenarios. First is if one parent is an NRI. So an NRI is an Indian citizen who resides abroad for employment, business, or other purposes. When one parent is an NRI, child custody issues can become complicated, especially if the child was born or is living outside India. So Indian courts often have jurisdiction if one parent or the child resides in India. However, if the child is living abroad with the NRI parent, international law and the laws of the foreign country also come into play. Courts prioritize the child's welfare and best interest, so they carefully examine factors like the child's connection to India, cultural upbringing, and schooling. In the case of Surinder Kaur Sandhu versus Harbakh Singh Sandhu, the Supreme Court of India held that even if a child is taken abroad by one parent, the Indian courts can intervene if the custody arrangement is detrimental to the child's welfare. The second situation is if one parent has an OCI card, that is, Overseas Citizen of India. An OCI card is given to individuals of Indian origin who are citizens of other countries. It provides many rights similar to those of Indian citizens, except for voting and holding public office. So if one parent has an OCI card, the situation is slightly different from an NRI case. Since OCI holders are not full citizens of India, custody disputes can involve the laws of their country of citizenship and Indian laws. The Indian courts can still have jurisdiction, especially if the child is in India or has strong connections to the country. However, in these cases, international treaties like the Hague Convention on International Child Abduction may also be relevant if the child is taken across borders without consent. In Sarita Sharma versus Sushil Sharma, the Supreme Court dealt with a case where the mother took the children abroad without the father's consent. Although the Hague Convention was not directly applied, the Indian courts emphasized that the child's welfare was the paramount consideration. The third situation is if one parent is Indian and the other parent is of a different nationality. So in cases where one parent is an Indian citizen and the other is a foreign national, cross-border child custody disputes become even more complicated. This often involves navigating both countries' legal systems and ensuring the child's well-being amidst cultural and legal differences. So when one parent is Indian and the other holds foreign citizenship, Indian courts still have jurisdiction if the child has a strong connection to India. The child's upbringing, their emotional and psychological needs, and their ties to both parents' countries are considered. Issues like international child abduction arise when one parent takes a child to another country without the other parent's consent. Since India is not a signatory to the Hague Convention on International Child Abduction, these cases can become difficult, but Indian courts may still order the child's return. Another important case is Ruchi Maju versus Sanjeev Maju, where the Supreme Court ruled that Indian courts have jurisdiction if the child has strong ties to India, even if the child is currently residing abroad. This highlights that the nationality or foreign residency of a parent does not negate Indian courts' ability to intervene in cross-border custody disputes. In the case of Arun Sharma versus Roxanne Sharma, the custody battle between Arun Sharma, who was an Indian national, and Roxanne Sharma, a US citizen, spanned over a decade, marking one of the most complex and prolonged legal custody disputes in Indian legal history. The couple was engaged in a legal battle over the custody of their minor son. Roxanne, the mother, was a US citizen, while Arun Sharma was an Indian national. The custody dispute was initiated when the child was very young, and over the years, both parents made claims for sole custody. In 2015, the Supreme Court of India ruled in favor of Roxanne, granting her interim custody of the child while Arun was given visitation rights. The decision emphasized the welfare of the child as the guiding principle in custody disputes, highlighting that the child's emotional and physical well-being would be best served by staying with the mother during the formative years. The court was cautious in ensuring that the child's connection to both parents, especially the father, was maintained through structured visitation. In a significant turn of events in 2022, after 11 years of legal battles, the Supreme Court allowed Roxanne Sharma to relocate to the United States with her son. The decision came after careful consideration of the child's best interest, including his well-being, education, and emotional stability. The court acknowledged that cross-border custody issues require balancing parental rights with the child's well-being. Roxanne, being an US citizen, sought to provide a stable upbringing for the child in the US. Custody disputes don't always need to end in bitter courtroom battles. Mediation is an effective way for parents to reach an agreement without putting their child through a contentious legal process. Under Section 89 of the Code of Civil Procedure, courts can direct couples to attempt ADR, that is alternative dispute resolution, before proceeding with a full trial. This often results in a more amicable solution, reducing stress for both the parents and the child. While child custody laws in India have evolved, there is still room for improvement. In countries like the UK and Australia, shared parenting and joint custody are more commonly awarded, something that India may soon move towards as societal norms evolve. The emphasis is increasingly on the child's best interest, and we may soon see legislative reforms that promote more balanced custody arrangements, ensuring that both parents play an active role in the child's upbringing. Child custody is one of the most difficult and emotional aspects of family law. It's about more than just legal rights. It's about ensuring the well-being of the child both now and in the future. If you're facing a custody battle, remember that the law is there to serve the child's best interest, and mediation or counseling can often provide a less stressful path forward. Thank you for joining us on this episode of Family Law Diaries. In the next episode of Family Law Diaries, we will dive into alimony and financial settlements. Who gets what and why? Don't forget to like, share and subscribe for more insightful content. Do share your thoughts in the comment section below. Stay informed, stay empowered.